Good morning to you. In continuation of our constitution classes, today we are taking up Article 17. We have already seen Article 14, 15, and 16. Now, under right to equality, Article 17 and 18 are left. Article 17 speaks about untouchability. It abolishes untouchability and forbids its practice in any form. If untouchability is practiced, it should be dealt with as an offense punishable under law. This right is available against private individuals, and it is the constitutional duty of the state to take essential steps to ensure that this absolute right is not violated. This right aims to establish a new ideology to the society, that is, equality to Dalits at par with others. This is not self-executory because it is like a resolution. So obviously, the state has to make a law to implement the provision of abolition of untouchability. Accordingly, Untouchability Abolition Act was made and it was renamed as Protection of Civil Rights Act 1955. Now, the term untouchability has not been defined in the Constitution. But the court has held that this term should be understood as a practice which has been developed historically in our country. That is, a practice largely available among the Hindus in which certain group of people are contemptuously looked down purely based on their birth. Remember, purely based on their birth. The Untouchability Abolition Act or the Protection of Civil Rights Act has made the practice of untouchability as an offense with the consequence that is, which includes insulting a Dalit, preaching untouchability, justifying untouchability, and refusing admission to Dalits in place of public resorts, etc. The punishment is very severe in the sense 6 months rigorous imprisonment. It is a cognizable offense, non-bailable, non-compoundable, and if a person is convicted, he is disqualified for contesting election for 6 years. Most importantly, the guilt is presumed. In the sense, in the jurisprudence, there are 4 basic principles. Every person should be treated as innocent. Every person is innocent until and unless the otherwise is proved. Number 1. No person should be condemned without hearing. Number 2. Every crime should be proved beyond doubt. If there is any doubt, the benefit of doubt should go to the accused. And number 4, no person can sit on judgment on his own decision. These are all the 4 jurisprudence principles based on principle of natural justice. So, every person is innocent until and unless otherwise is proved. It is the duty of the state to prove that a person is guilty. But that is not applicable in the Abolition of Untouchability Act. If a person has been charged with the offense of practicing untouchability, it is presumed. So the onus lies on him to prove that he is innocent. And interestingly, a survey conducted in 2014 has revealed that 27% respondent confessed that they practice untouchability. Of these, Jains constitute 35%, Hindus 30%, Sikhs 23%, Muslims 18%, and Christians 5%. Across the states, Madhya Pradesh is the highest with 52% practicing untouchability. And the least is West Bengal with 1%. So, this is the position about abolition of untouchability explained in Article 17. Now we are coming to Article 18. The Article 18 has 4 provisions dealing with abolition of titles. First provision prohibits the state to confer any title to any person. Military and academic distinctions are exempted. This is the first provision. The second provision prohibits the citizen to accept any title from any foreign state. First address to the state, don't give any title. Second is address to the individual, citizen. It prohibits every citizen to accept any title from any foreign state. The third provision prohibits any foreigner holding any office of profit under the state to accept any title from any foreign state without the consent of the president. Remember, third is any foreigner, if he is holding an office of profit, he should not accept any title from any foreign state without the consent of the president. And the fourth provision is, it prohibits any person, whether citizen or non-citizen, holding any office of profit to accept any present or emoluments or office from any foreign state without the consent of the president. Remember, these are all the 4 provisions under Article 18. Article 18 is not self-executory. So the state has to make a law. But no law has been made so far. So it is only directory. In 1954, the government introduced 4 categories of decorations. First is Padma Shri, then second is Padma Bhushan, third is Padma Vibhushan, and fourth is Bharat Ratna. The Bharat Ratna occupies 9th position in the warrant of precedence. The warrant of precedence has been prepared by Ministry of Home Affairs, tabulating the high-ranking dignitaries according to their rank, right from President of India, followed by Vice President, Prime Minister, Speaker, et al. So, it occupies the Bharat Ratna awardees occupy 9th position in the warrant of precedence. Supreme Court has categorically said that these Padma awards cannot be used as a title. In 1996, Supreme Court upheld the constitutional validity of the what is called Padma Awards. In 1977, Morarji Desai government stopped awarding these Padma Awards. Subsequently, 1980, Mrs. Indira Gandhi government revived this. However, keeping in view of indiscreet discretion on the part of the government, the government itself has made certain guidelines. They constitute a committee to identify the potential awardees, and the High Power Committee recommends awards. Similarly, the decorations should be withdrawn if the awardees have proved that they are misusing it. So this is the position about Article 17 and 18. So remember, up to this we have seen right to equality consisting of Article 14, 15, 16, 17 and 18. Now we are coming to right to freedom, which includes Article 19, 20, 21 and 22. All these four rights put together we call as Magna Carta of Civil Liberties. Of these four rights, remember, Article 20 and 21 cannot be suspended, important, even during emergency. Nevertheless, Article 19 stands automatically suspended during national emergency if the national emergency was declared on the ground of war or external aggression. See, first let us take Article 90. Article 90 has 7 freedoms. Freedom of speech and expression, freedom to assemble peacefully without arms, freedom to form union, association and cooperatives. The cooperatives term has been added through 97th Amendment Act 2012, which also incorporated Article 43B on cooperatives in the directive principles of state policy. And fourth freedom is freedom to move throughout the territory of India. Fifth is freedom to reside and settle in any part of India. Sixth is freedom to acquire, hold and dispose of property, which has been deleted through 44th Amendment Act 1978. Then seventh freedom is freedom to practice any profession, trade, business or avocation or occupation. These are all the 7 freedoms, of which 1 freedom has been deleted, and at present we have 6 freedoms. Even though it has been deleted, we should keep in mind. There can be a question, which freedom has been deleted? Because for the first time in constitutional history of India, one fundamental right has been deleted, Article 31, as well as the freedom to acquire, hold and dispose of property. Both these have been deleted through 44th Amendment Act 1978. So we should remember from the PT point of view. Secondly, the question is whether these freedoms are absolute, unbridled. No. There are restrictions in the Constitution itself. In the Constitution itself, there are restrictions. Remember, man is a national being. Normally, every human being desires to do many things. But in a civilized society, the desires of any person should be controlled, reconciled, and regulated in their exercise by similar desires of his fellow citizens. Therefore, remember, there cannot be any right which is absolute and simultaneously injurious to the society as a whole. Remember, why the restrictions have been kept? This is the reason. Now, the guarantee of each such freedom has been restricted in the Constitution itself by conferring the powers on the state to impose by law reasonable restrictions. Remember, the restriction should be reasonable. Only thing is, such restrictions should not be arbitrary. And who will decide the arbitrariness or otherwise of a restriction? It is for the judiciary to decide, to test and decide whether any restriction imposed by the state is arbitrary and whether there are over restrictions. So, the judiciary can always judge the reasonableness of any restriction. And most importantly, remember, Article 19 is available only to citizens. Now, first let us come to freedom of speech and expression. Remember, freedom of speech and expression includes freedom of press also. There is no separate freedom or separate article which covers freedom of press. Freedom of press is inbuilt in the freedom of speech and expression. What is press? Press echoes my idea, your idea, and communicate to others. And it is a combination. Their own idea, the idea or the stand of the press through its editorial, and my views, your views, and others' views are all communicated through the press. And press is the fourth estate, and it is the pillar of democracy. So naturally, freedom of speech and expression includes freedom of press also. You may not have forgotten Right to Information Act 2005. It has emanated from freedom of press. The right of the people to know about the background of the candidate before voting, it has emanated from this. Setting up of Prasar Bharati as an independent organization emanated from this article. Most importantly, freedom of speech and expression includes freedom of silence also. In the Yahweh case, in Kerala, among the Christians, there is a community called Yahweh community. They will not worship, they will not salute, they will not show any respect except to Jesus. In one of the school, when their national anthem was sung, the director of public instruction during his visit observed 2 kids did not sing the national anthem. So he suspended both the kids from school. They filed a petition before the High Court of Kerala. High Court upheld the order of the Director of Public Instruction because there is a clash between the fundamental duty and fundamental right. So naturally, fundamental duty prevailed over the fundamental right. The order of Director of Public Instruction was upheld. They filed a writ petition before the Supreme Court. Supreme Court clarified right to freedom of speech and expression includes freedom of silence also. If any person wants to be silent, he cannot be compelled to speak. The children stood honestly, they stood respectfully, they did not sing. Merely because they did not sing, it does not amount to an insult. So Supreme Court nullified the orders of the Director of Public Instruction so that it aside the topic. What I say is, freedom of speech and expression includes freedom of silence also. And remember, this freedom can be restricted on the ground of sovereignty, integrity, security of state, friendly relations with foreign state, public order, morality, contempt of court, defamation, and incitement to offense. Remember, maximum restriction. Why? This is aligned with the freedom of press. Because freedom of speech and expression and freedom of press both are combined here. Maximum restriction, 11 grounds are given in this article. So the restrictions can be imposed by Parliament by making law. It cannot be through executive order. It should be only by making a law. Second comes freedom of assembly. Remember, this includes the right to hold public meetings, demonstration, and take out procession. Remember, the assembly must be peaceful and without harm. This right does not include right to strike. Remember, right to conduct bandh. It does not include right to conduct bandh. Does not include right to strike. Your section 144 of CRPC and 141 of Indian Penal Code derive from here. So any procession, unlawful assembly, they can more than 5 people can be restricted under section 141 as well as 144. Remember, 144 of CRPC, 141 of Indian Penal Code. You should know the difference if there is a question. More than one person, that is restricted under section 141 of IPC, and 144 is the unlawful assembly. So both are emanating from freedom of assembly here. This can be restricted, remember, on the ground of SIPO, SIPO. Easily you can remember: sovereignty, integrity, and public order. Then comes the third comes freedom to form union, association, and cooperatives. Remember, this is very important. This right includes freedom to form political parties, companies, trade unions, and also remember this right includes not only to initiate, not only to start, it includes to discontinue also, and it continue also. So you commence an activity, trade union, you have a right to continue, you have a right to discontinue. This right can be restricted on the ground of SIPO, sovereignty, integrity, public order, and morality. Remember. Then comes what is known as right, freedom of movement, freedom to move throughout the territory of India. This right emphasizes that India is one, intended to promote what is known as national feelings and brotherhood. This right can be restricted in the interest of general public and protection of the interests of any scheduled tribe. Remember why scheduled tribe? To protect their distinctive culture, language, custom, and manners of scheduled tribe. So remember, Supreme Court in a case held that the freedom of movement of prostitutes can be restricted on the ground of public health and morality. So this is freedom to form union, association. Then comes freedom of movement. Then, and the freedom, when we talk of freedom of movement, remember it has two dimensions. One is internal, that is a right to move throughout the territory of India. Second is external, a right to move outside India and come back. The second part is being dealt with in Article 21. That is Article 21, that is right to life and liberty. No person shall be deprived of his life or personal liberty except by a procedure established by law. That is given in the external part. That is to move, right to move outside India and right to return to India. This is dealt with in Article 21. So that we will take separately. Then comes freedom to reside in any part of India. After movement comes freedom to reside and settle in any part of India. Remember, this is to remove all the barriers within India. The restriction can be imposed on two grounds. One is in the interest of general public, and also second is for the protection of the interest of scheduled tribe. And finally, freedom to practice any profession, trade, occupation, or business. Very important. So a person, a citizen can move throughout the territory of India, settle in any part of India, and he can practice any trade or business. And this right is very wide. It covers all means of livelihood. State can impose reasonable restriction in the interest of general public. In addition, it has got the states, the control has got more powers. It can prescribe professional and technical qualifications for conducting any business, and the state can carry on itself any trade or business or industry in complete or partial exclusion of the citizens. What does it mean? That is, the government can prescribe Medical Council Act, Pharmacy Act, Chartered Accountants Act, prescribing professional qualification. This right derived from this article. Secondly, nationalization of banks, nationalization of transport, nationalization of insurance. Again, this has been derived from this right. So, we have seen all the 7 freedom given in Article 19: freedom of speech and expression, freedom to assemble peacefully without arms, freedom to move throughout the territory, freedom to form union and association, freedom to move throughout the territory of India, freedom to reside and settle in any part of India, freedom to acquire, hold and dispose of property which has been deleted through 44th Amendment Act 1978, freedom to practice any trade or business in any part of India. All the freedoms, 7 freedoms we have seen under Article 19. So 20, 21 and 22 we will see in the next class. Thank you very much. If you like the video, kindly subscribe and put in the indication that you like it. Thank you.